My everything is you, Lord. Yeah. Oh, 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 oh. Everybody say, ah. Say, oh, oh. Say, how can I express
my gratitude
for all the many things?
all the many things you've done for me?
Words are not enough, yeah.
Enough to say thank you.
Say, Lord, you are my everything.
You're my everything.
How can I express my gratitude
How can I express my gratitude
for all the many things,
all the many things you've
Father,
done
you
for
done
me?
for me, yeah.
Words are not enough to say thank you.
Say, Lord, you are,
Lord,
you
you're
are.
my everything.
Say, I call you Zion.
Lord, my provider.
I call you Nisi. You are my battle. I call you Rapha. Hey.
You are my healer.
Say, Lord, you are.
You're my everything.
I call you Jireh.
Lord, my provider.
I call you Nisi. You are my banner. I call you Rapha.
You are my healer.
Say, Lord, you are. You are.
You're my everything.
Who am I thinking now?
Hello, lovely people. Another wonderful Saturday afternoon is here with us on BWTV, bringing you the community and the law. My name is Oreku Frimpon. The question I'm asking you is, what do you do if the Home Office has cancelled your leave and has given you 60 days to leave the UK? What do you do? I've got an answer for you, so I want to invite you to come join me on the program, The Community and the Law, brought to you by BWF Solicitors. Let's get into it together.
Hello. Yeah, you're good. Hello. There are several questions in the community when it comes to the law, especially with immigration matters. That is why I'm inviting you to join us on the program, The Community and the Law, live on BWTV and brought to you by BWF Solicitors, our trusted partners when it comes to the law. We are going to have a very massive discussion on some of the issues of immigration matters that bother you. And they have the opportunity to meet you live on the program to explain to you all the updates that have come from the Home Office and also address your questions and concerns that you might have when it comes to the law. The Community and the Law is brought to you every Saturday between 4 p.m. and 6 p.m. UK time. We're live on all social media platforms, YouTube, Facebook, and LinkedIn, at BWF Solicitors, at BWTV, and of course, we urge you to share the program and invite others to join us. Remember, it's at 4 p.m. to 6 p.m. every Saturday, live on BWTV. You have your questions. There are answers. So join us, learn, and empower yourself on the program, The Community and the Law. So pick up the phone and dial 0208 493 7345, or you can send a text 07950 422 780. It's The Community and the Law. My name is Oreku Frimpon, and I am your host.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Hello, once again, and thank you so very much for your time, your space, and of course, the energy with which we come together on the program, the community, and the law. Once again, my name is Usu Frimpon, and I am privileged to be sitting in the seat and leading the discussion on what we have this afternoon. We're coming your way courtesy of BWF Solicitors, our trusted partners when it comes to the law. BWF Solicitors is located on the 4th floor of the Anna House, 214 to 218 Tottenham High Road, Seven Sisters, North London. Now, when it comes to immigration matters, when it comes to all the other legal issues, family, when it comes to family, we talk about marriages and divorce and how you can use those situations in your immigration issues, appeals, and all the other bits. BWF Solicitors are the trusted friends. So let's go to them every Monday to Friday between 9:30 in the morning and 6 p.m. in the evening. Call them on 0208 493 7340. The number again 0208 493 7340. They also have an office in Ghana where you can reach them on 055 589 5959. The emergency number is 077 127 61884. 077 127 61884. Anyway, if you just joined us, you are live on Facebook, you are live on YouTube, and all the social media platforms. And I will urge you to announce your presence when you come on in the comment section below. And then what you need to do, pick up the link, share it on your various platforms, and also like the page. And click on the subscription button so that when we put up any content, you will not miss out on that. It's the community and the law right here on BWTV and live. This afternoon, I have a very interesting topic, and it's in the form of a question. What do you do when the Home Office says that they have cancelled your leave and have given you 60 days to leave the UK? So what do you do? Obviously, you'll be telling me I need to speak to my lawyer. Yes, you need to speak to your lawyer, but there are other things that you need to know when it is that you have to speak to your lawyer or even respond to the Home Office. We'll be going into that detail. But then we also have some updates for you when it comes to immigration matters here in the UK. And first off, I start with this one. Exceptional route for those who cannot meet the high maintenance requirements is what I have for you. There may be situations where the sponsor and the applicant cannot meet the financial requirements for Appendix FM to show income of £29,000 per annum. Now, if they cannot, paragraph Gen 3.11b comes into play, and it states that when there is a credible guarantee, when there is a credible prospective earnings, and where there are any other credible and reliable source of income, if you've seen application will lead to unjustifiably harsh consequences for the applicant and their family, these things will come into play. And we're looking at paragraph Gen 3.1 to 3.3, Appendix FM of the immigration rules. That's our nugget, and later on I will introduce my resource person, and he will be telling us a lot more of that. What other things do I want you to learn of and know about? BWF Solicitors brings this one. Yeah, the community update says the Home Office cannot revoke your sponsor license without listening to you. Now, if the Home Office intends to take action against you about your sponsor license, you must be heard and also given the opportunity to respond to their allegations before they make their decision. Now, look at this quote. The common law right to be heard before important benefits are taken away is fundamental. Unquote. Now, I'm telling you this, if they fail to do that, and according to our community update brought to you by BWF Solicitors, if they fail to do that, their decision will be found to be inconsistent with published policy, contrary to a legitimate expectation, and procedurally unfair under common law. So if your business is facing suspension or revocation, please, I will ask you, speak to our specialist lawyers. BWF Solicitors, 214-2218 Tottenham High Road, Seven Sisters, North London. Call them now on 0208-493-7340. And remember that update I gave you is a case that was between that is New Hope Care Limited and the Secretary of State for the Home Department as 2024 England and Wales High Court case 1270. Okay, so that's that. I'll be giving you some details of that. But the third one I'm bringing you is a video that the senior partner of BWF Solicitors made earlier in the week, talking about these situations, a fee waiver, how to sort those things out, and also get yourself in a good situation. Ladies and gentlemen, let's watch this.
Hello, today's video is to look at the fee waiver for those who are making human rights application, either FLR, FP, FLR, M, FLR, L, FLR, O, HRO, or the human rights applications will qualify for fee waiver. The Home Office guidance clearly sets out those applications, and this covers the parent route, the spousal route, the private life route, and then the protection and the trafficking route. So all these routes will fall under the human rights application. Now, as those of you who will be conversant with the immigration application around this area, the fee is quite expensive. The Home Office fee currently is $1,048. That is going up to $1,258 on the 24th of July. And then the immigration health surcharge is $1,034 for a year. So your typical 2.5 years plus the Home Office fee is about $3,635.50. 3,635. That is your typical 2.5 years. Now, if you're a family of 2 or more, obviously that is quite expensive. The fee that is waived on the application by the Home Office for those who cannot afford it There are four main classes of people who cannot afford the fee. First of all, those who are working and cannot put money away to pay. Second are those who are not working and do not have any income. Third are those who are facing imminent destitution. Either they're going to lose their homes or they're going to lose their jobs. And finally, those who are destitute. So they do not have a home to live and they do not have any income. All these people will come under the affordability test. The essence of the fee waiver is to ensure that those people who haven't got the money and the resource to pay are able to rely on the Home Office to waive the fee. So the fee waiver is that the fee will be waived and you will not have to pay any fee. The application is made online and you have to support the application with your financial details. This will cover your bank statements if you have bank statements, your pay slips if you have pay slips, or if somebody is supporting you, then they have to give you a letter. If you're living with someone, then they have to give you a letter and a proof of the accommodation. Please, we've heard many times that there are people who believe that if you're working, then you do not qualify for fee waiver. Now, the assessment is based on your living expenses. The living expenses includes your accommodation, your council tax, your food, your utility bills, your telephone bill, your broadband, your travel costs, and even an allowance is made for your social life, your religious life, and other aspects of your life, including your clothing and grooming. So if you're earning an income and at the end of the month you're not able to put money away to cover this fee, my advice to you is that you qualify for the fee waiver and you need to make an application. The application is taking up to 8 months, sometimes even more. Please, if you wish to apply, make sure your application is put in early before your visa expires. But even if your visa expires while it's being considered for the fee waiver, under the law, you still will be covered. And although your visa is expired whilst your application is being considered, you will be deemed to be living here legally. I hope this video is helpful. However, if you have further questions, please contact BWF Solicitors. Please like our social media, your YouTube, your Facebook, your LinkedIn, and your TikTok.
There we go. So if you have any issues, you have any concerns, and if you want any further information, just talk to BWF Solicitors. I'll give you the numbers again, and it's at the bottom of your screen as well. 0208 493 7340, or the Ghana number 0055 589 5959, or the emergency number 077 127 61884, 077 127 61884. Now, I'm getting you very ready for our discussion this afternoon, and it's about what you do if the Home Office has cancelled your leave and giving you 60 days to leave the United Kingdom. I believe if you find yourself in this situation, definitely you would want to stay and listen through as we go for the discussion. But in the meantime, let me recognize those who have graciously joined us. Tilly Duma is always doing that. Sylvester Fojo on YouTube is online here with us. Thank you, Sylvester. Good job, you say. Thank you so very much. Tilly Duma, I mentioned your name earlier on. The Nigerian Senior Minister Brawai, and the class is going on. Yes, Nigerian, you've been called. Please come on. If you come on board, please also announce yourself so that we see you. Alex will say hi, everyone. Hi, Alex. Thank you very much for your time. Next, we have Tilly, who is asking us to share. Please kindly share, comment, and like. Thank you. Yes, do that for us, and we're so appreciative of that. Akuya Nima, are you there? Tilly is calling. Nana Akuya Breye Ajimai. Next, we have Nanahima Sapong being mentioned to come on. Kofi Nat backing Mayor 1. Yes. Abigail Osemensa, yes, you're on the register. They mentioned here. Michael Barr, they mentioned here. Eben say name mentioned here. We waiting for all of you to announce your presence, and then we can definitely get on with that. But remember, we're doing this courtesy BWF solicitors are trusted partners when it comes to the law. Let's take their messages, and we'll be back.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contestant and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner, with over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
We're back and still on the program, The Community and the Law. Remember, later on when we activate the lines, you can call us on 0208 493 7345. Or you can send a text or WhatsApp to our number 07399 208 468. 07399 208 468. I've just been reminded to take the nugget again, so we'll be going to that. Then I'll introduce you to the question that I'll be asking later on in the day and on the program. Exceptional rates for those who cannot meet the high maintenance requirements. So watch this. You remember the video that Uncle Ben recorded and we played back. I would want to really emphasize that. So let's look at this. There may be situations where the sponsor and the applicant cannot meet the financial requirements for Appendix FM to show income of £29,000 per annum. If they cannot, paragraph Gen 3.1(1)(b) comes into play, and it states that where there is a credible guarantee, where there is credible prospective earnings, or where there are any other credible and reliable sources of income, there will be an exception to this. So if refusing the application will lead to unjustifiably harsh consequence for the applicant and their family, then Gen 3.1 to 3.3 Appendix FM of the immigration rules kick in. So just take note of that. And I will want to ask this question. So let me take you into the scenario. Benny Whaler wants to bring his wife into the UK from abroad. He cannot meet the financial requirements because he has only been working for 2 months in the UK. He works at Nana's Food Joint, earning just about £17,000 per year, or per annum as they say it. Nana's uncle, a gold dealer with £60,000 in savings, offers to support Nana's wife's application. Let me take you back to the nugget and ask you and see that again, and then we'll come back to this question. Now, it says if they cannot, paragraph Gen 3.1b comes into play, and Gen 3.1 talks about where there is a credible guarantee, where there is credible prospective earnings, or any other credible and reliable source of income. Okay, now back to the question. It says that Nana's uncle, who is a gold dealer with £60,000 in savings, is offering to support Nana's wife's application. So I'll ask you the question: what evidence must he provide in support of the application? One, 6 months of bank statements and the letter of support and evidence of his own circumstances. Two, a letter of support and passport copy, or an undertaking and his house documents. So look at the three scenarios very carefully. 6 months of bank statements, a letter of support and evidence of his own circumstances, a letter of support and passport copy, an undertaking and his house documents. Benny Whaler wants to bring the wife. He doesn't have the money. He only earns 17,000. His uncle has 60,000 pounds in savings and wants to support the application. So I'm asking, what does he need to provide? Think about that, because at the tail end of the program, I am going to ask you to give me answers to this question. Is it 1, 2, or 3? Anyway, we're still live on BWTV, and the program is the community and the law, brought to you by BWF solicitors. You want to know about them? Watch those.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contestant and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Hello. There are several questions in the community when it comes to the law, especially with immigration matters. That is why I'm inviting you to join us on the program, The Community and the Law, live on BWTV, and brought to you by BWF Solicitors, our trusted partners when it comes to the law. We are going to have a very massive discussion on some of the issues of immigration matters that bother you. And they have the opportunity to meet you live on the program to explain to you all the updates that have come from the Home Office and also address your questions and concerns that you might have when it comes to the law. The Community on the Law is brought to you every Saturday between 4 p.m. and 6 p.m. UK time. We're live on all social media platforms, YouTube, Facebook, and LinkedIn, at BWF Solicitors, at BWTV, and of course, we urge you to share the program and invite others to join us. Remember, it's at 4 p.m. to 6 p.m. every Saturday, live on BWTV. You have your questions. There are answers. So join us, learn, and empower yourself on the program, The Community and the Law. So pick up the phone and dial 0208 493 7345, or you can send a text 07950 422 780. It's The Community and the Law. My name is Oreku Frimpon, and I am your host.
Well, thank you very much for still sticking around. We'll be going into the discussion very soon. What are we discussing this afternoon? We're looking at a situation where the Home Office has cancelled your leave and has given you 60 days to leave the UK. So what kind of leave are we talking about? You're a student and your leave has been cancelled for various reasons. We'll be looking into that. You are on the skilled worker route and your leave has been cancelled for whatever reasons. We'll be looking at that as well. And then probably any other situation. And they say, well, you have 60 days to leave. Do you have to immediately pack your stuff and leave? I don't know. The answer would be coming. But if you don't have to, what do you do? Obviously, you would want to contact a legal person who will help you do that. So this afternoon, I'm going to get us to go into BWF Solicitors once again, and Lawyer Charles Asma will be helping us look at that situation where you've been given 60 days to leave. Prior to that, he will also be telling us about the nugget situation where we're looking at Gen 3.5, 1 and B. Then again, we'll also be getting into picking up your questions and your concerns. You can leave them in the comment section below on Facebook at BWF Solicitors and on YouTube at BWF Solicitors and BWTV as well. It's all live on the Community and the Law. Ladies and gentlemen, we're bringing you a resource person, Lawyer Charles Asma from BWF Solicitors. Yes, you're watching with us, and Passmore. You're watching with us. We also have Mami Ajima who's watching with us. Sandra Fraser is online. We have David Lechu. We also have Sakina to Blankson, Legal Know-How. I believe it must be another platform that is picked up the link. And also, Pastor Augustine Abuaji on PAM TV. Thank you very much for watching with us and putting us on your platform as well. Tilly Duma and all the others. Now, Larry Assessment, as I said, is our resource person. Uncle Charles, good afternoon.
Good afternoon, Brother.
Thank you for watching and just sticking around and coming to watch with us, and also helping us to educate our people. Now, I mentioned earlier on a nugget where we're talking about somebody trying to get an application through, but does not fully meet the income. And yes, it says that exceptional route for those who cannot meet high maintenance requirements. Kindly help us, as you say your good afternoon to us, kindly help us to look at what the requirements are and what these exceptions are as well.
Thank you very much. Once again, viewers and listeners, welcome. And today we are going to learn another new thing which will benefit most of us. But for now, we are looking at the nugget. Greetings from BWF Solstice. So the application under family life, that's a family migration appendix FM provisions and other provisions. But for this one, we're looking at family life application. Now, with family life application, especially as partner, you have to meet financial requirements. Again, you also have to meet requirement for children. But in this scenario, or in this nugget, we are looking at sponsors sponsoring those and who must meet the financial requirement. When we say financial requirement, the rules say that it must be £29,000. What it means is, if the person is not able to meet that aspect of the criteria, which is the financial requirement, ability to fend for yourself without recourse to public fund, they will not be able to apply, or they will not be able to tick that box and succeed with the application. So what can they do? Now, we have to look at the context. We are looking at family migration. What it means is, this is Article 8 right. So that somebody must have right to family life. That means they must join their family or remain with the family. If they're not able to do so because of constraint, and that constraint is the financial requirement, if they're not able to meet it, that means they cannot assert their right within the rules or under the law in terms of Article 8 family life. So what happens? There will be family disintegration. And the law says that when it comes to that point, we have to go beyond the rule and look at the exception.
Okay.
So what is the exception? The exception is that if you're not able to meet the 29,000, we have to check whether the exceptions will apply under Gen 3.1. And again, we have aspect which is 3.2 and taking you to 3.3. What do they say? What they simply mean is that if you are applying for application, be it in country or entry clearance, and you don't meet the rules, we have to see whether the exceptions can apply to your circumstance.
Okay.
First one being that there is a guarantor. In other words, there's a credible guarantee. So somebody will step in to say that I am sponsoring. Not sponsoring as the person bringing you, but sponsoring the maintenance, in that they are providing their bank statements, earnings, and everything to show that once you enter.
So in that case, do they have to give you up to the 29,000, or they can top up what you have?
So if the person, it says that if you don't meet it and you have a credible guarantee, that guarantee, obviously the person who is putting themselves up for that guarantorship will be able to meet the 29,000. So let's take the full loan instead of in bits. So there is a credible guarantee or guarantor. The second part, because we are taking viewers through the exceptions. Let's go to exception number 2. Exception number 2 is that there's credible earning, and here it says prospective earning. What it means is that you haven't had the job for 6 months,
Okay.
but the job is likely to go beyond 6 months, potentially a permanent employment.
Okay.
But you just had it. Can you apply, or do you have to wait for 6 months? You can apply. What it means is that that prospective earning, which meets the threshold, will suffice, in that it will continue, so that even when the person joins you in the UK or remains with you in the UK from month 1, when you put in the application, the income will continue. And therefore, but you have to then show that this is credible prospective earning. Why do we say credible? It shouldn't be fake. You cannot make it up. In this case, the employer should be genuine, and that earning, which is on your employment contract, because you haven't received pay slip.
Yeah.
So that earning on your employment contract, you say that you are earning 31,000 or 30,000, should come from a credible employer. So that when we want to verify the employer status, it will be possible to meet that verification check. So they can check from Companies House, they can check from HMRC, they can check from all other sources. And if it is taken to be that the company exists or the employer exists, then that is credible. Again, whether the employer is able to meet that so-called earning that you say you are going to be giving. So if the employer is not able to afford, how would they know? So they will check places like Companies House filing record. So let's say the Company House filing record shows that this company's we are now in 2024, 2025. Yeah. So let's say 2023, 2024 tax record show that the person turnover or income before tax and deductions was about 50,000.
And the person says it's going to give
will be,
it's going to give you,
and the expenses, we are going to add 30,000 to our expenses before we take from the 50,000.
Then it's not credible.
Would that be credible? See, so there will be a question mark, and that will flag up. So those are the
so in this case, if I show the Home Office that I have an employment contract that says it's going to give me 30,000, which is more than the 29,000, and that helps me to meet the threshold. When I go to check from Company House and the company does not have resources enough, then it means that my prospective job is not credible.
It's not credible. The earning is not credible. Either the earning cannot be sustained, or the earning is just made up from the beginning.
Right.
So that cannot be reliable. And the third criterion, producer, if you take us to the third criterion under the exceptions, it says that any other credible and reliable source of income. And that will include your savings, that will include your investment fund or anything that is liquid enough. When we say liquid fund that can be used at any time. So if you have a fixed deposit and there's no way you can dip in and dip out, then that will not be a sort of a reliable, because that fixed deposit, you cannot use it until a particular period because it's ring fenced. But if, for example, you have ISA, individual savings account, or you have general or standard savings account, you can dip in and dip out. So that is reliable and credible source of income. So these are your personal incomes, sources of income beyond your employment income. And that, so once you are able to take all this, or one of them applies, then we say that if the person is not allowed on the basis of the exceptions, then the refusal will bring what we call unjustifiable hardship. To who? To the family members concerned, children concerned, partners concerned. And therefore, that is the case, that it breaches the person's Article 8 right, family life. And here, so the rule under Gen 3.123 applies. And at the same time, we're looking at the case of Ajaku, which says that when there's family life application and the person cannot meet all the rules, and on that basis they are refused, and that refusal will not be good for the family, then case law says that it is not fair in all the circumstances. So the point is that even if you don't meet the financial requirement, you can apply, provided it can take
the boxes. So if you have any questions, any queries about this, we have advised you to contact BWF solicitors who will help you out. 0208-493-7340, 0208-493-7340. And I have posed a question based on this nugget, and I'm saying that Bunny Whaler, who wants to bring his wife into the UK from abroad, he cannot meet the financial requirement because he has been only working for 2 months in the UK. He earns £17,000 per annum. So what happens? His uncle, who's a gold dealer, has £60,000 in savings and has offered to support. So look at the three scenarios and give me the correct answer. 6 months of bank statements, a letter of support and evidence of his own circumstances, a letter of support and passport copy, and or another taking and his house document. We'll be coming back to this, but let's now look at what we are discussing this afternoon. The Home Office says that they have cancelled your leave to stay in the UK and have given you 60 days to leave the country. What do you do? Pack your stuff, go to the airport, board the plane, and go back to your country? Or is there anything you can do? Laura Charles Asma is ready to help us through that. Why would the Home Office cancel anybody's visa?
Thank you. So we will start off with the context so that people understand, as you asked. Why would the Home Office say that you have 60 days to decide what to do? To decide, including leaving, because leaving is also a decision. So you have 60 days to decide what to do. Why would they say so? So let's look at those aspects of leave that would trigger that warning.
Yeah.
Students.
Okay.
So you've entered the UK as a student to study. So your purpose of entering the UK is to study. Now, to be able to study, you have to have the university. So let's assume that whilst in the UK and studying, the university folds up, i.e. the government shuts the university down so that they cannot sponsor students again, or for whatever reason, they are not able to meet certain compliance processes, and so they are not able to operate. And they tell all the students to go and look for another university, and you are one of them. That means you cannot remain with that employer, with that university. So what happens to your student visa, which is held by that university? It becomes invalid.
Okay.
And if it is not valid, whose fault? It is not your fault. It is the university's fault for not doing the right thing. But the fact that it is the university's fault, and because they are holding on to you, if they are in trouble, you are partly affected. Okay. So, because it's not your fault, they will tell you that this has happened. 60 days, decide what you want to do. So that's one.
Okay.
The other one is you are a student. Again, they find out that the way you acquired the visa itself to enter the UK is problematic. And so your visa is cancelled. But once your visa is cancelled, they won't give you 60 days. Why? Because in that case, it is your fault.
Okay.
So if it is your fault, there's no warning.
That's straight away.
If it's your fault, then it might be that you acquired through misrepresentation, falsehood, which would trigger, which if they had found out, would have been a refusal under part 9, paragraph 9.7.2 of the rules, which says that if you use deception and misrepresentation to get a visa, to beat the system, and you are found out, the visa will be curtailed if it's already given, or the application will be refused under that mandatory refusal criterion. So if it is your fault, punishment is that you will be given 60 days. If it is not your fault, then equity requires that you are given opportunity to decide your options. So we are looking at people whose misfortune is not as a result of their own doing.
Okay.
It's as a result of their sponsor. So students, if the sponsor's problem has affected them, they will be given a warning.
Okay.
Another one is to do with individuals who have entered the UK to work for employers, skilled workers, all category, not just health.
The health worker.
But when we say skilled worker, our
people think that is the health worker.
The health industry. No, every industry, healthcare, or whatever. So let's say skilled worker visa holder.
Okay.
You come in, expectation is that you continue to work for that employer. And for whatever reason, the employer is punished by way of license revocation or inquiries going on, and they find out that they cannot continue to operate as license holders.
Okay.
Because they are affected, you are also affected. But whose fault? The employer. If it's the employer's fault, should you be punished without a warning?
No, it wouldn't be fair.
That would not be fair. And therefore, fairness and reasonableness will require that you be given opportunity to decide your options. So again, we have two pathways. So the question, viewers and listeners, we want to ask ourselves is, if my visa is
curtailed,
not curtailed per se, if my visa becomes problematic for whatever reason, is it my fault or somebody else's fault? If it's somebody else's fault, you'll be given opportunity to decide your options. If it is your fault, then the visa will be cancelled, or of course, once the visa is cancelled, they will tell you that this is it. If you have a problem, go to court, which is administrative review and judicial review, or where they are lenient, they will ask you to go have an appeal right. So if it is your fault, you may be given admin review right or appeal right if it is your fault. If it is not your fault, you'll be given 60 days to decide what you want to do. And I think it's clearer now.
Okay.
Now, so we are assuming that
we are working with the 60 days now.
We are working with 60 days where the issue has arisen through no fault of the visa holder. So this is the individual we're going to work with. This individual is called John, simply.
Okay.
So John has received a letter from the Secretary of State, which says that XYZ has happened. Therefore, you have 60 days from the date of this letter, which will be at the top, to either make a new application or go home. They don't just say go home. They say make a new application or decide what you want to do. But sort of, it's simply that you go home.
Because the original one says go home. Yeah. So either you do an application.
So once you are given the option, our question today is, what do I do if the Home Office has cancelled and given me 60 days? And now the cancellation has arisen because the visa is no longer valid. Because of the employer's situation, or because of the university's situation, or because you did not attend and the university has informed the Secretary of State. Okay. What do we do? And that is our question.
So, ladies and gentlemen, if you just joined us, the question is, what do we do? Where do we go? And how do we do what we have to do? Now, it's not your fault. I think lawyer has really established that. It's not your fault. So, in that situation, you have the 60 days to decide what to do. I am going to ask him to help us know, and of course, just go around what we need to do and do it right. And I'm still asking you to be with us on BWF Solicitors TV. We are live on the program The Community and the Law, and brought to you by BWF Solicitors. Lasma, what do we do?
Yes, what do we do? So we will look at our legal options and take each option in turn. So option one. Okay, so you came in as a student. So you had a student route under appendix student. You have decided within the 60 days to switch to something else. Question is, what can you switch to? We know that if you're a student, you cannot switch to health and care visa. You cannot switch to skilled worker, so to speak. And we are giving specific areas. So let's take that if you're a student, you cannot switch to skilled worker until you have completed the course. And if the university is in trouble, there's no way you can complete the course. So there's no go area in terms of work visa. That means you have to target family visa.
Okay.
Family visa means you are going to apply as a partner or as a parent.
Okay.
Partner or parent. And you see that partner or parent fall under family life applications, Article 8.
All right.
So what you are saying is that, yes, within these 60 days, I want to remain in the UK with my family because once in the UK, I have formed a relationship with this lady or this man, and we want to remain in the UK.
Okay.
Let's look at that bit. That means you are going in as a partner. But if you're a partner, the rules say that you have been in a relationship for 2 years.
Okay.
So that relationship criteria or threshold must be met. 2 years in a relationship. If you are married, it is when you started living together. But if you are not married, it says 2 years in a relationship.
Okay, so let's get it clear. So I'm switching from student visa to a family route. I should have been in a relationship for at least 2 years if I'm not married to the
Yes.
person.
That's what we used to call cohabitation.
Cohabitation.
Today, it is no longer cohabitation because the rules have changed recently to say that a partner is this, and the relationship should be akin to marriage and should be in a relationship, not should be living together.
Okay.
So that's the difference now.
So if I am married, then I don't need to prove that I've been in a relationship for 2 years. But do I have to stay at the same place with my my husband or wife?
So it appears, looking at the rules carefully, that the rule is saying that if you are in a relationship, it's more to do with your heart. If you are in marriage, it's your heart and your whole being.
Okay.
So if it is your heart and your whole being in marriage, then you cannot be living apart. If it's your heart which is in that relationship, then your heart can be living at separate places but connected.
Okay.
So the relation. So I'm trying to break it down. Therefore, if it's a relationship, you don't have to be living together for 2 years, but you must show that you've been in a relationship for 2 years.
Okay.
So it could be that you are living together and you moved apart because of work and other reasons, but you are still in that relationship and you have things in common to show that you are in that relationship. So it's not about cohabitation, but it's about genuineness of the relationship.
So if prior to my predicament, I was married, now the Home Office is giving me 60 days to leave because my visa is no more valid or useful. If I got divorced within that 60 days, would they allow me to get into another relationship or into another marriage and use that to prove that I can stay in the UK?
Good point. So that is the bit I was going to get to, where we have single individuals who are in this situation. They have no strings attached to them, and therefore they move freely. And if they have been in that relationship, they just progress it. Or they are married, they can continue. Now, we have to take it in that reverse order. You are applying to remain with your partner or your husband or wife, not because you want to remain with them, but because you are together already and it is good to have that family unity going.
Okay.
So you are not marrying to remain. You are remaining because you are married or you are in that relationship. Because the rule is that there should be genuine and subsisting relationship. So if the relationship is not genuine and subsisting, and it appears to the person assessing your application that the person is in this relationship because of the intended application, then that will call for assessment under sham marriage or sham relationship.
That's when they call you for interviews and the rest of it.
Well, not interview. Of course, if they suspect anything, they will call for anybody can be asked to attend interview as part of the rules. However, if the application is assessed and the caseworker suspects that the person is going into this because of that, how would the person know? When people come to me, I say there's common sense process and the legal process. You asked, how long should a person separate or be separated before they remarry to remain with their new partner or wife? So let's say this person, so that is for those who were already married, and for whatever reason, the marriage has broken down irretrievably, and they have divorced or severed that relationship, and so they are moving on into another relationship. You move on to another relationship. There's no law which says that if you break one, you cannot start another. There's no law. It's your feeling, it's you. So there's sociological aspect, which means that says that if you break one and you see another, you can start that another. But when you start that another, what are you going to use it for? If you start that another, you are going to use it for this. Then it appears that you are starting this other one because you want to take advantage of something. Okay. So how would they know that this is your intention? Because intention cannot be seen. So we assess the context and see that on the balance of probabilities, it appears that this is the intention. So let's take an example. So this student has had this warning, and within that 60 days, they divorce. Within that 60 days, they remarry. Within that 60 days, they make a new application. Application is the third one. Divorce, remarry, application. Question: what is the purpose of this remarriage? Is it because of the application, or the application is just secondary? And looking at the time frame, it appears that everything has been rushed through with the purpose of beating the deadline for this purpose. And then it will be seen by reasonable bystanders, ordinary person with common sense, observers that it appears, looking at the context, that the purpose of this marriage is for this. Okay. So that is why. So your question is how long? How long does it have to? There's no time frame, but common sense tells you that. And what is common sense? For me, my common sense is this. You see, when you leave one relationship, it's painful, isn't it? Yeah. Genuine relationship, it's painful. And once bitten, how many? Twice shy. So will you rush into another with all the uncertainties? Difficult. No. And therefore, sociologically, 6 months will be too short. Sensically, too short. 1 month, 2 months, 3 months will be so quick. Hey, would you feel back now another one? What's your motivation? But if there is lapse of time, you've healed, and you are going into another one, what's your motivation? Because you've been alone for some time. It's difficult to be alone because it takes two to tango. And therefore, if you're able to tango well, you need another. One has gone, you found another with like mind, and therefore you are willing to go ahead to be able to tango. And so you've been together for some time, and now you are wishing to remain with this new partner. After some time, it makes sense that this marriage is not for any reason but for marriage. So I ask people, is this marriage for marriage, or is this marriage for something else? And if the caseworker asks this question, so I always ask the question that the caseworker so you preempt it, answer it for them, and deal with it with the application process. So that even if it comes up at the application assessment stage, you've already preempted and resolved it within the cover letter and the documentation that you need to be able to support that application. So even if it appears to them that it is rushed through, or it is for whatever reason, that is their business. Let them think so. But you have everything to prove that it is genuine and subsisting enough to make it credible. So that even if it goes to court, the judge will say that on the balance of probabilities, it appears that this is not a sham marriage. And if you think so, prove it. Because once the burden shifts from you to the home office, they have to. So first, it's on the home office to prove. that it's not a genuine marriage. Then, if you're able to also prove that it is a genuine marriage, then it goes back to them for them to prove otherwise. And that is where, during the cross-examination in court, for example, you'll be asked several questions, and the judge will make assessment based on your responses. And again, the caseworker will also want to test this genuineness by calling you to ask you questions at the application assessment stage, interview. So even if you go to the interview and because of stress and everything else, you are not able to give them the answers that they want because you are human. When you go to court, the judge will be able to assess that. Forget about what happened there. What we see here shows that this is a genuine and reliable or credible relationship. So that's the relationship aspect.
Okay. If you just joined us, I would want to urge you to get your presence felt by announcing yourself on the comment section below, either on Facebook or YouTube. We're live on the program, The Community and the Law, and our resource person and guest from BWL Solicitors is lawyer Charles Asma. What do you do when your leave has been cancelled by the Home Office and be given 60 days to leave the UK? Is looked at one of the situations, which is where you can form a relationship. But the other bit is where we're looking at a young person or a child involved, and he's going to help us do that. It's a community and the law.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contestant and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Yes, I believe that you're still here, and once you're still here, I would want to see your comments in the comment section. And remember, very shortly we shall be activating the lines 0208 493 7345 for you to be able to come on. If you have a question on the topic we are discussing, you can bring it up. Or if you have any other question, Lawyer Charles Asma will be gracious enough to do an answer for you. Then again, you can put your questions and your comments in the comment section down below, either on Facebook or YouTube. And remember, the program is The Community and the Law. This afternoon, we're discussing what to do if the Home Office has cancelled your leave and has asked you to leave within 60 days. Lawyer Asma, you mentioned earlier on that what to do, as we were discussing, that you could look at the relationship scenario, either in a marriage or in a durable relationship. And then earlier you mentioned that there could be a child involved. How does that play out?
Thank you very much. So we've looked at the relationship gateway,
Mm-hmm.
i.e., by marriage or by relationship.
Mm-hmm.
We've also looked at the fact that timing is of essence.
Okay.
And therefore, if it appears that everything has been rushed through because of the application,
Mm-hmm.
it raises eyebrow. The next thing is, again, on the family route.
Mm-hmm.
This time, not as a partner, but as a parent.
Okay.
So as a parent, you are applying to remain with your child. And the child here, under Section 117D
Mm-hmm.
of the relevant statute, it says that a qualifying child,
Okay.
and a qualifying child is somebody who is a British child or has indefinite leave to remain,
Mm-hmm.
has pre-settled or has settled, or has lived in the UK for 7 years, either by birth or by private life, let's say brought in to the UK.
Okay.
So that is the sort of child you can say you want to remain in the UK with.
Okay.
Now, again, under that, there are two gateways. So the first gateway is to do with biological child.
Okay.
And the second gateway is to do with stepchild.
Okay.
So the biological child here, if you are a man or a woman, the child may be living with their mother or father.
Mm-hmm.
And you, the baby mama or the baby papa or father, live elsewhere.
Okay.
But you play the
significant role,
that active role
mm-hmm.
in the life of the child. What is active role? You are a caring or responsible father or mother. So even though the child doesn't live with you, you are concerned. You check up on them, you visit them, you take them around, and you are part of the child's life.
Mm-hmm.
So you are playing active role. The law says you have direct access to that child.
Okay.
And if you have direct access to that child, what you need is evidence that you are in the life of the child. So we have GP confirming,
mm-hmm.
or we have school confirming, we have the mother of the child confirming.
Okay.
If you have that, that is one piece of legal evidence. The other piece of sociological evidence will be things to show that you are in the life of the child indeed.
Okay.
And that will be photographs with your child
mm-hmm.
and the child's mother. You tell you are there holding the bottle, giving the child milk
mm-hmm.
or food or whatever, changing the nappy, singing to the child to sleep.
That's not very typical of African men.
Right, but we are looking at responsible parents who have active role.
Mm-hmm.
If you play active role, you want to see it in action.
Okay.
Remember, nobody will follow you to the house to see you
doing it.
So how do you prove it? The
Pictures
photos that you
video
take
evidence
for memory purposes. You cannot take video because you can't send the video with your application. If it is caught, you may send that piece of evidence.
Okay.
But with Home Office, you add the photographic evidence of that memory that you have had with a child, and you continue to do so for future reference.
Well, the men who are not, how do I put it, who do not want pictures taken and stuff like that, please starting doing that, because memories are forever and they could be very beneficial later on in there. But timing, is it not another thing that will be considered here? For instance, I've just been given 60 days to leave. Then out of the blue, a child I care for appears in the picture.
Right. So let's deal. So we talked about the man. We said man or woman
mm-hmm.
who have direct access. But so what it means is that if you are the mother of the child,
mm-hmm.
and at the time of the child's birth,
mm-hmm.
you, the mother, was married to somebody whom you came to the UK with
mm-hmm.
as a partner.
Mm-hmm.
That marriage should have dissolved before you gave birth.
Okay.
Otherwise, the child belongs to the man.
The man, who's in the marriage.
Leave maybe has also been questioned,
mm-hmm.
and you are both in the 60 days conundrum together.
Yeah.
So that child will just be like you and that guy, because
mm-hmm.
the child takes after you.
Right.
So if you are a woman, the law does not expect you, if you are married, to have a child
outside of the marriage.
outside of the marriage. If you have it, you bring it home. The law is so, I don't know why the law is set out like that. But at this point, the law does not say that if you are a man, you cannot have a child outside of the marriage. And therefore, if you have a child outside of the marriage, and if you are a man, you can still rely on that child whom you have direct access with to make an application. Somebody will say, but this favors men. Well, at this point, that is what the law says.
Right.
Yeah. So, but if you are a woman, you had the child with a British citizen or somebody with indefinite leave to remain, then what it means is that the child automatically will have British citizenship or nationality. And so, even though the child is living with, for whatever reason, living with some men, will be living with their children. You see, there's one application I did. 2 children were living with a man, and the man didn't want the woman to have anything to do with the children. So the father was looking after, or the guy was looking after the 2 children. Then the lady came. What do I do? So, okay, do you still play a role in the lives of those children? She said yes. And we applied under direct access, and she had her leave based on that.
Right.
So, but hers wasn't within the 60-day thing. But this is for people who's based on the 60-day conversation we are having. So, direct access gateway. Then we go to the family route gateway, what we call Gen 3.2 gateway. So the Gen 3.2 gateway is a family unit. And family unit, we are looking at you married to the child's mother. And the child mother, so in this case, the child is not your child, it's somebody else's child.
Yeah.
But by the virtue of your marital relationship with the child's mother, the child becomes your stepchild, and the law sees you as a stepfather or stepmother, either way. And so you can rely on that relationship to apply to remain with that stepchild and that partner you have. So again, timing.
That's my most critical concern.
So if you are a woman, for men, okay, let's say both men, how long does it take in terms of gestation period? It's 9 months.
9 months, yeah.
36 weeks. Okay. So, when did you enter the UK to be able to father a child? So, we check when you entered the UK, and we calculate that it is 8 months, unless the child was born premature. Otherwise, it wouldn't make common sense to say that you are the father of a child born before you entered the UK, supposedly. So that's one. But in terms of stepchild, the child was born before you entered the UK, but you've married the child's mother.
Well, that's obvious. That's obvious.
Therefore, there's no calculation of date for us to look at the gestation period and the dating order. So that one, no issue. But with this one, if this is your child, you have to show that it's possible that you can father a child within that period, or you can have you can give birth to a child within that period. For women, they have to carry or bear the child for 9 months and give birth, and therefore it's obvious if you gave birth to the child in the UK. But for males or men, you don't have to carry the child in your child. I don't know whether men also have women.
We don't have women.
And that's why I wasn't there. So you don't have to carry the child biologically. And therefore, all you have to prove is that you fathered the child. But we want to see whether it is true that you could have fathered the child and whether you've been in the UK for. So when people come to me and say, oh, I have a child. I say, oh, really? Let's do the calculation. Does it make sense that at the time you enter the UK, up to the time you are talking to me, commonsensically, you can be a father? Not that you can be a father anywhere, but to this child. So the child was born, let's say today, and 8th of June. And you've been in the UK, let's say 8th of June 2023, which is more than 9 months. Then it's possible that that child could be yours because it's more than 9 months. But if you haven't, then it doesn't make biological sense that you can father, unless you are saying that the lady came to the country where you were living in.
But that will also have to be proven.
You also have to show that the lady in terms of travel, indeed. So those are the permutations, and that's why it's not just about I want to make an application.
It's really, yes, that's the point I was trying to make, that it doesn't necessarily mean that those routes and openings are there. You'd have to calculate it, apply the common sense approach to it, so that when you put in an application, you preempt the questions, answer all of them, and then you are certain that you'll be successful with the application, isn't it?
Yes. So I mean, so there's something in law. We say that res ipsa loquitur, means the fact speaks for itself.
Okay.
So if the fact is that you are the father, you are the father. If the fact is that you are the mother, you are the mother. But the evidence will suggest what the claim you are making.
Okay.
So whether the reason why we want to test the evidence by going through the dating order and all this is just to be sure that the claim is founded.
Okay.
If the claim is not founded, then you are not making a reliable application. Okay. Because the caseworker will be making the same assessment to test your evidence. So you are not doing the calculation with the view to meet a criteria. You are doing the calculation to make sure that what you are saying makes sense.
It makes sense.
So I don't want anybody to misconstrue the conversation to take it that the lawyer says that you have to calculate. You don't have to calculate if it is obvious. But what we are saying that if you come to me or go to a good lawyer and you say that this is your claim, they want to see that it makes sense. And they will ask questions, including when you entered the UK and how long you've been in the UK and whether it is indeed possible that you could be the father of a child born last month.
Right. Before we allow our viewers and various patrons to come in, I want to ask this question. This kind of application, is it at the discretion of the caseworker to grant based on the argument you gave, or once the evidences speak for themselves, the caseworkers do not have any option than to grant the application?
So, thank you. The rules are set out. So within the immigration rules, just as we looked at financial requirement, there's also relationship requirement.
Okay.
So if the relationship is parent relationship, then we want to see that you are the father or the mother, birth certificate.
Okay.
So within the Children Act 1989 of the UK, it says that the mother of the child is obvious, the one who gave birth. The father of the child is the one whose name is registered on the child's birth certificate. Or so what we call the documented father. Then if this person is not the documented father or biological father, they want to go to the extension of the fatherhood to see whether this is a stepfather. If we can see the test or assess the test of stepfather, we take it, then that is also a father. So you can show that is one piece of evidence, birth certificate. But the birth certificate for that child, some people will say, should my name follow the child's name? I mean,
it doesn't.
Names are sociological, and therefore you don't have to name your child after you. Some people name their children after their best friends, after their dogs, after whatever. So that the name of the child should not necessarily be the same as your name as a father. But we want to see child, mother, father, child's asthma. Okay, then that is the father. Whether the child is called asthma or not, that's not the point.
That's not the point. Okay.
So the name of the child and the name of the father should not necessarily be the same. That's point one. The second point is that if you are married to the child's mother or father, then the evidence here will be two, because we have to triangulate it. So we have the child sitting there, we have the mother who gave birth to the child, And the relationship between the mother and the child will be the birth certificate.
Okay.
And we have the mother and this new father of the child, which is the stepfather. So the husband of the mother of this child. The relationship will be marriage certificate. And therefore, if this woman is married to this man, and if this woman is the mother of this child, then we can apply.
We can join the line from the son and the child's
property. So commutative property will apply here. So we are applying mathematics. So if A is B, and so if A is B and B is C, then A is C. Logic. And therefore, once we have these two pieces of evidence ticked, child step relationship is established.
Okay. Yeah. So then my question then comes in that the caseworker would not have anything to doubt if you can properly prove that those relationships or the three joints or the 3 points are dotted and joined together. Then they would have to grant the application.
So you are proving relationship. One, so this is the obvious evidence of relationship. Then we have the secondary, so the primary evidence and the secondary evidence. The secondary evidence is what you are claiming, that you are not just a father or a mother, but you also have direct access.
Okay.
Because we have irresponsible fathers and mothers, but you are responsible, and so you have direct access to your child. And because you have direct access, you play a role, and this is the evidence of the role you play. The photos, the letters, that will come, and that's what. So you can see that you have two categories: the primary relationship and the secondary relationship, which is the role you play. Then if you are the stepfather, the same way, the primary relationship and the role you play within the family unit in the life of your step child. If you're able to prove that with everything else, so the question is, why would the caseworker say no? Because the rule say X, Y, Z. So if your rule say X, Y, Z and have met X, Y, Z, on what basis?
On what basis can you deny?
Then you have to prove why you think it's no.
Well, it sounds very interesting, very straightforward, but you'd have to put and apply common sense to the whole thing. Lawyer Charles Asma is our resource person from our sponsors, BWF Solicitors, and we're live on the program, The Community and the Law on BWTV. We're going to ask you to come in. If you have any question or concern, you can bring that to us. Lawyer Asma is here, who will help us answer all of them. Mami Ajiman comes up first. He says, my friend is applying for British citizenship, that is naturalization. Does my friend require their EU national partner's payslip or any documentation for evidence in regards to British citizenship application? My friend is applying for British citizenship, naturalization. Does that friend require their EU national partner's payslip or any documentation for evidence with regards to British citizenship application? Last one.
Right. Okay. So when you get to citizenship or nationality application, it's just you and your God, so to speak. I just put it crudely. But what it simply means is that it has nothing to do with sponsorship.
Okay.
If you are doing indefinite, you still have to show that you've been living with the one who brought you there. But when you are going for citizenship or naturalization, it's you. Show 5 years of residence in the UK. You, not your partner. Of course, they will ask you if you have you live with your partner, blah 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 blah. But the evidence is not based on your partner. It's you and the evidence. So where are we looking at? We are looking at the relevant aspect of the law. So section 6 of the immigration rules. If you look at the relevant schedule, it says that if you're applying for naturalization, show one, that you have indefinite, held for 1 year, depending on your circumstance. 2, show that you have lived in the UK for 5 years or 3 years, depending on your circumstance. 3, show that you have English. 4, show that you have life in the UK, or show that you are exempted from English and life in the UK. 3, show that you have not been absent from the UK for 450 days within 5 years, or less than that if you are operating within 3 years of residence. And therefore, if you're able to go through and provide this, whether your husband gives you or your whatever it is, your application, and therefore they can't say no on that basis. And I think that will answer our
question. Okay, so we can pick another one, or in the meantime, you can call us on 0208 493 4 or 5. Let's pick some other comments there. Thompson Abrokwa, good afternoon, lawyer. I have 5 years stay. I'm married to EU, but she has passed away. Can I marry again and bring her to the UK?
Right. So 5 years stay, that's pre-settled. 5 years is pre-settled. So if this is pre-settled, you cannot sponsor your partner to enter the UK under your pre-settled. You must have settled status. So if you want to remarry and after that relationship, you want your wife to join you to remain with you in the UK, you can, but you need indefinite leave to remain or settled status. So once you are 5 years, go for your settled status application because you qualify under retention of rights because your sponsored wife is dead. So you can go for that settled status. Once you've had your settled status and in future you remarry, you can bring your new wife to live with you in the UK.
Okay. Let's take a couple more. I think Mami Ajima, yes. Is the English proficiency test B1 necessary for British citizenship if they have an indefinite leave to remain and lived in the UK for more than 10 years? He says again, my friend would like to bring her auntie and cousins to her graduation in the UK. How could she bring them since they live in Ghana? Context, she graduated in the UK and lives there. Okay.
Okay, that's fine. So the first one, if you're applying for indefinite leave to remain in the UK or naturalization to become a British citizen, one of the requirements is English language. And here you need to prove B1 or B2, C1 or C2. C1, C2 equivalent to degree standard. So if you have degree taught in the UK, you are exempted. If you have a degree taught abroad and you have ECTIS comparability letter, you are also exempted. Otherwise, you have to sit the exam and pass either B1 or B2. Question, do you go for B2 or you go for B1? You are going for B1, but based on your performance, you end up having a result of B2, which is higher than B1. But the benchmark is B1 for indefinite and naturalization.
The second question.
The second one, you want to come for graduation and you want to know whether you can come with family members. Of course, anybody who is celebrating that milestone, attend that program with family members. The question is whether those family members will be given or not.
Oh, no.
And they have to show that they will return after the graduation. If they are not able to prove that they will return, then they fail the returnability test under appendix visitors and they will not get the visa. He says the main person lives in Ghana. Of course, the main person who lives in Ghana went maybe after the papers and they will come back for graduation. So they will get a visa and come for their graduation. But the others are different because they are not coming to graduate. And they have to show that when they come, they will return.
Yeah. So can they apply together? For instance, the graduate and the other family members, he or she has gone back to live in Ghana and would want to come for the graduation.
Can they apply together?
Can they apply together as a group?
Well, there is no applicant 1, 2, 3 on the same form, but there's applicant on one form. So if they are going to apply, they can apply at the same time, but not necessarily together in the sense of one form. So there will be 3 forms to be submitted. And of course, the evidence or the supporting document may be the same because it's a family.
Okay. From the United States, we have our dear sister and friend Frida watching with us. Thank you very much. What time is it there? It's about 12 noon. That's good. Yes, you can send in your question on your concerns 0208 493 7345. Jefta Kusi says, good afternoon. I'm planning to apply for British citizenship. What form should I be looking for and what documents do they need? I'm married to an EU partner and got indefinite leave to remain in 2017. So I've lived here for 13 years. I have heard that I should apply for something relating to a 10-year route for my British citizenship, but I don't know what that is or means. Please let me know.
All right. So this person says that I've lived in for 13 years. So I mean, okay. So naturalization. It used to be the case that you have to look at the date of your marital relationship And that's why they say wait for 10 years.
Mhm.
But when the rules changed, they said that they have to standardize the residence period. So it's 5 years across board. Now, 5 years across board means that you should have held your indefinite leave to remain. You said you have held your indefinite leave to remain for 1 year. So they can apply. If you bring it, what are they asking for? What form? So you're going for the naturalization form. So you go for that. So you type naturalization application. The form pops up. We also have the document you need. And I think I've gone through the document already when I was answering the previous question. I said that show absence period.
Yeah.
Show 5 years residence. Show English and show life in the UK.
Yeah.
Unless you are exempted by age or by disability. Show your indefinite leave to remain for 1 year, held for 1 year. So once you tick all the boxes, yes, those are the documents you require to support your application.
Maybe as a follow-up to this, let's look at a scenario where somebody for the past 10 years has been outside of the UK, even though before the person left the UK had indefinite leave to remain. Would that be invalid as of after 10 years?
I mean, so the thing with indefinite leave to remain is that when you are applying for indefinite, they'll ask you, do you want to take UK to be your main home? And you say yes. What does it mean? So there's what we call 2 years continuous absence. So you go away, but you have to return within that certain period, unless due to illness you've been away and you intended to come, but illness caught up with you and you couldn't return in time. But 10 years appears to me that you have chosen to live abroad, unless of course you have a reason. Otherwise, you can again make an application to return, what we call right of abode.
Oh, okay.
Yeah.
All right. So if the person gives the excuse that because of marriage and family that I had to relocate, kind of, would that be accepted?
But remember, when you have indefinite leave to remain, you are not a British citizen.
Yeah.
You are a foreigner. Where you choose to live your life is nobody's business.
Okay.
So if you choose to live abroad with all the risks associated with it,
Okay.
so be it. But in case you change your mind, what will be the steps? And
So
that's
then
what
you
I've
apply
told you.
for right
So it's
for.
not a case of I'm returning after 10 years, having decided to leave the UK and make somewhere else your main home.
Okay. All right. And would the requirements be the same as applying for indefinite leave to remain at that time?
No, that would be different. So right of abode, you have to then show the things that will. So every application has its own criteria and documents support it. So if you are making an application and as a returning resident, you have to look at the requirement under that provision and apply and support your application with that.
Okay. If you have any questions or concerns, please text us on 0739920848. That's on WhatsApp as well. Or you can put your comments in the comment section below, either on Facebook at BWF Solicitors or on YouTube at BWF Solicitors. Or you can call us on the line 0208-493-7345. As I keep saying, when you join us live on the show, announce your presence and leave a comment there. Margaret Edumenson says free legal education. Jefta Kusi said earlier on that the person coming for the graduation is in Ghana, but he says it's in the UK.
Yeah, so
it's about the same
we
thing.
answered both.
Okay.
That usually the person will be in the UK and inviting
Invite
the
people to come over.
So if you are inviting them, then you're only looking at those invitees' applications, but you are already here.
All right.
But they have to show that they will return.
Rama Nana Sewa, you are watching with us. Thank you very much. Junior Agenda, you're also watching with us. Thank you so very much. Now, we would have to, yes, I'm picking up another one, and then we'll take a quick break and come to a quiz where I asked you about the financial requirement, meeting it, and also the exceptional situation. The Home Office requested bank statements for a certain period as proof of continued residence in the UK when I applied settled status as EU national. Does it mean they want to know if I was actively in the UK based on my transactions, savings, or something else? What will happen if I am not able to provide all the statements requested because there wasn't any transactions at that period?
Right. I mean, I don't think they ask for bank statement per se. They ask for evidence of residence in the UK for 5 years, because that's what you have to prove. But when you were applying for the first time, you were given pre-settled 5 years because you didn't meet the 5 years test. You couldn't show that you've lived in the UK. So you can only show that you've lived in the UK for 1 year or 6 months or whatever. However, now you have lived in the UK for 5 years. So if you are working, you have P60s and P45s. If you are not working, you have your bank statement. But the bank statement, if the bank account is dormant, then there will be no transaction to show those years that you need. So that evidence will not be relevant or reliable. You then have to look at something else. Voting documents, so the voter card or the poll card that you get every year or anything else, could be letters, hospital letters, and what have you. What they want is 5 years. But because you gave them bank statement to prove your residence, that's why they said, give us 5 years of bank statement, not just less than the 5 years you gave them. So if you don't have bank statement, give them something else that shows that you've been resident in the UK for 5 years.
Okay, there's another question there. Frida says, how does a person permanent in the UK get the girlfriend in the US to permanently join him in the UK?
So the person permanent in the UK has indefinite leave to remain. And yes, and the person has indefinite leave to remain, the girlfriend is somebody whom they have durable relationship with. And the rules say that the relationship should be akin to marriage, similar to marriage. So they have to do everything that married people do.
One is living in the UK, one is living in the US.
And that's why the rules changed to say that you don't have to be living together.
Okay.
You must be in a relationship together. And that's, I call it relationship in heart. Yeah. Well, because marriage, you must be together. So that's heart plus physical unity. But in terms of relationship, if the one is in the US and one is in the UK, you visit each other, you communicate, you do this, you do that, and all that. Yes, as long as you're able to prove that everything points to the fact that this is a relationship similar to marriage, what will you prove? You've been going on holidays together, so you go to the person maybe hasn't come to you before, but you always go to the person. So you have your travel itinerary, all the communications you've had. Sometimes you meet elsewhere to have
go on holidays to have fun,
to have your unity or your relationship time together, and so on and so forth. All this will be will support. It might be that you have some insurance policies together. Yeah, that will also support your. So my brother is a brother, yeah.
No, it's a sister.
Oh, our sister. So our sister, if you want to bring your, get the girlfriend in the US, a girlfriend. How does so the girlfriend is in the US, isn't it?
Yes, that's
so this is our brother.
No. The lady is the name is a lady.
Oh,
how does a person permanently?
How does okay?
So
referring to those prospective clients.
the boyfriend should be in the UK.
Boyfriend is the one asking the question through the friend.
Through the friend. Okay.
Yeah.
All right.
So this is Frida just a sender, a messenger. So our friend can bring the girlfriend provided the criteria and the relationship are met.
Yeah. Okay. While we're taking another quick break, there's one. Anyway, I'll pass it on to Laura later on. It's the community on the law, and we discussing what to do if the Home Office has cancelled your leave and giving you 60 days to go out of the country. What do you do? Now, before we take the break, I would want Laura to just round at that point. Then
yes.
we can
so because we are gradually ending, I just want to point out that all this while we've looked at student. But if you are already in the UK as a skilled worker, and for whatever reason, as we said, the employer, through the employer's fault, you are warned with 60 days notice, then you can obtain another employment and switch to that new employer. That one is possible. But if you're a student, then you cannot go to that.
Okay.
Again, if you're a student, the dependent, your dependent can switch to a skilled worker, but you cannot switch. And if the dependent switches to a skilled worker,
then you become
they cannot tag you along, because you still remain a student with that status before this happened, and therefore you can't become a skilled worker dependent or skilled worker main.
All right. Well, with that, gives us the signal to take our break, and when we come back, it's the quiz.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contestant and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Welcome back. We're still live on the Community and the Law Live on BWTV. What to do if the Home Office has cancelled your leave and has asked you to leave the country. That's what we have been discussing. But we have been taking your concerns and your calls. One final one, and we go on to our quiz. I need to bring my daughter to join me in the UK, but my status does not permit it. What can I do, please? Because she is still underage. When refused, one can head to court for help. Laura, let's look at Buki's question.
Okay. I think Buki made it clear that she doesn't qualify at this stage, because it says that my status does not permit it. So if your status doesn't permit it, then you cannot bring your child. Let's say this person has 2.5, not yet indefinite, or has pre-settled, not yet settled. Then they cannot. So on this basis, we say that wait till your status permits you to bring your child. The second one, when refused, can one head to court for help? Of course, every refusal except visit refusals that you cannot go to court. Even visit refusal, you can still say that even where you are not given the right to admin review or appeal, you can still go to court, because the decision was made by a government agent or official who has made mistake in law per your assessment, and therefore you can still go for judicial review, even if you are told that you cannot go apply, you can't have an appeal, or you can't have an admin review. Judicial review is available to any decision that in your view is in error. So the answer is yes.
Right, and with that, let's look at our question again. Benuela wants to bring his wife into the UK from abroad. He cannot meet the financial requirement because he has only been working for 2 months in the UK. He works at Nana's food joint, earning £17,000 per annum. Nana's uncle, a gold dealer with £60,000 in savings, offers to support Nana's wife's application. What evidence must he provide in support of the application? 1, 6 months of bank statements, a letter of support, and evidence of his own circumstances. 2, a letter of support and passport copy. Or 3, an undertaking and his house documents. What is your answer? Keep them coming through. You can text 0739920848 or put your answers in the comment section below. The correct answer is number 1. Kevin Asamoah says so. Is there any other? Kweku Asamoah says number 2. So Kevin says 1, Kweku says 2. Who says number 3? I thought I would have a sequence. Yes, I did. Abigail Dia says number 3, an undertaking and his house documents. Who else? Keep them coming. 0 to Lydia Paul says 1, which is 6 months of bank statements, a letter of support, and evidence of his own circumstances. Then the other one, Abenecha says number 1. Who else? Let's see what you have, so we can quickly go to Lawyer Asma to help us unravel and pick up the correct answer. Amasapon says number 2, a letter of support and passport copy. What else? Junior Agenda says number 1, 6 months of bank statements, a letter of support, and evidence of his own circumstances. Tilly says number 1. Tilly Duma says number 1, 6 months of bank statements, letter of support, and evidence of his own circumstances. Yes, Tilly, we've had yours. Sandra Usu says number 2, a letter of support and passport copy. And then Frida says number 1, 6 months of bank statements, a letter of support, and evidence of his own circumstances. Bernard Fosu says number 1. After Bernard, I think I'll take just one more and we go over to Lawyer Charles Asma. What would be the right answer?
Right, thank you very much. So the nugget context tells us that you have to look at GPS. GPS, G stands for credible guarantee or guarantor, an undertaking.
Yeah.
The P, as I have put it, stands for credible and reliable prospective earning.
Okay.
And the CS, I call it S, is your other source of income. So GPS. So if we go through Wheeler's context, Wheeler's context, we are looking at the G, because we're looking at GPS. G, that's a guarantor. Is there a guarantor?
Well, it says
yes,
the uncle
so that's guarantor.
has 60,000.
So guarantor, checked, but we look at whether it's within 1, 2, or 3. Then we look at prospective earning. Prospective earning will be it's not here because there's no. We are not saying that he's found a new job. We say that he earns
17,000, and he's been on that job for just 2 months.
That will go under so a bit of prospective earning, which is credible, and at the same time other source of earning. Just that is not enough, and because it's not enough, he will need a top up for the
G.
So yeah, from the G. So 6 months will be from his 17,000 salary, and also, but you can see that he's only been there for what?
2 months.
2 months. So we can't have 6 months, but we have 2 months of that. Again, there will be bank statement. There will be bank statement. So we're looking at the bank statement and the pay slip for that 2 months payment.
Okay.
Then prospective, because again 17,000. Then we also have the letter of guarantee. So the letter of guarantee is the main thing. 60,000 from the uncle will support whatever Wheeler has to show that even though I don't meet 29, I fall under the exceptions under Gen 3.31 to Gen 3.33, and therefore the refusal will be harsh, will bring unjustifiably harsh consequence for me and other partners, my partner and other family members involved, and therefore we'll go for 1.
So, lawyer says 1 and 6 months of bank statements and a letter of support and evidence of his own circumstances. Now, let's see what explanation as lawyer has. They will accept credible and reliable guarantee, evidence support, and a letter detailing how a refusal amounts to unjustifiable harsh consequences. And I like the way lawyer Hasma has put it: GPS, guarantor, prospective, and your
other
source of income.
Yeah.
Oh, lovely. You don't get this from anywhere apart from BWF solicitors. And with that, those who said number one, you are correct. Let's go over to Lawyer Charles Asma again for a summary of our discussion this afternoon before we draw the curtains down.
Thank you very much, viewers and listeners. So today we have said that if you are warned with 60 days notice, that should not be the end of life. You can progress to something better because there is light ahead. So what do you do? What are your options? We said that you can then migrate to a family route as a parent or as a partner. Parent or partner, you have to prove that you are a parent to a British child or a qualifying child, so to speak, or you are a partner. You are a partner to a wife who is British, and the person is having a child, which makes it easier because on the basis of the child, it's easy for the application to be considered successfully. But it just you and your partner may be difficult because they may ask you to go back to your country and both live there. But you can apply if you have your own child and a direct access to switch. What we didn't mention is the private life route. With a private life, we know that you have to be 20 years. So if you are not 20 years in the UK, then you cannot apply under private life fully. However, private life partially says that if you have less than 20 years residence in the UK, you can apply if you have obstacles, which means that your removal from the UK will be unjustifiably harsh. In that case, you need to prove that obstacles to support the less than 20 years that you have. So again, if you are waiting, if you feel that the 60 days is going to expire soon, what you can do is to put in your private life application whilst you are waiting to explore what your other options. What it means is that once you put in that private life application, you can vary the application to something else within the family private life route. So those are the conversations we have had for today. And you can see that you don't give up until there's no way out. Take action and there is green light ahead.
Take action, there's green light ahead, and the green light is that I'm inviting you to join us for another edition of the program, same time next week. Thank you very much, Lawyer Charles Osman, for your kind presence and, of course, your share of knowledge and experience. And to BWF solicitors, from the very top to the last person like myself, we say thank you very much to all of you. And we would want to say continue to do what you're doing and support us. And to you viewers out there, what would I have done without you being there? Now, once you've stayed and liked the show, please like the page, share the page, and also click on the notification button so that anytime we put content on, you will be notified and you not miss out. And to my studio director, Professor Ade, and to Padmo Dudu and Sheila Ankra for the admin and the aesthetics, my name is Oreku Sifrimpon. Have a good evening.